The difference between negligence and strict liability. Yes, there is. There is a difference between negligence and strict liability. The difference is that in a products liability case, there was a case years and years and years ago that invented products liability by a guy named Learned Hand. What a great name for a judge. His first name was Learned, Learned, Hand. Anyway, if a manufacturer has a duty to put products in the stream of commerce that are not defective or dangerous when put to the reasonably anticipated use. That is what products liability law is. So if you have a product that is dangerous or defective and that causes an injury to a person, that is strict liability. The product manufacturer, the person who made, designed, manufactured, and distributed that product is automatically liable for the damages that defective or dangerous product caused. Now, that can sometimes be different people. Somebody may have designed it, somebody may have made it, somebody may have distributed it. If that's the case, all three are strictly liable. Although most states have a statute that says if all you did is distribute it and the manufacturer's in the case and is solvent, it can pay the judgment, the distributor can get out. Missouri and Illinois have that statute, and many states do. So that's what strict liability is. Negligence is you have to, it adds another layer in that proof. You can have strict products liability. You can also have negligent products liability. Negligence products liability isn't strict. That's the difference. What negligence says adds another requirement that says that the manufacturer, the distributor, something had to be negligent in that design. So there are some products that are dangerous, but they were not negligently done. For instance, there's a lot of construction equipment, jackhammers, bulldozer stuff. If a bulldozer comes down on your foot, then and maybe this is a bad example, but that is, did it hurt you? Yes, but that's not negligence for the product manufacturer. So product manufacturer, then a negligence is a different standard for products liability. Usually when we plead, and there can be different jury instructions for negligence or strict liability. In strict liability, comparative fault may not apply. In negligence, it's comparative fault because if someone's using the product badly. Negligence also brings into account a failure to warn. So there are some products that have inherently dangerous natures to them, like a bulldozer, like a pool, like a trampoline. But if a manufacturer warns of those dangers, then they can get out of liability, saying, we warned you guys that. You guys know when you're driving a car, you can't, it goes 80 miles an hour. That can be dangerous. You got to be careful. So we're going to have warnings about that. You can't look at your phone while you're driving, that kind of stuff. So now the question is whether that warning was adequate and whether it was non-negligent. If it wasn't negligent, if the warning was good, plastered, that red diamond that says warning, don't do this, clear, communicated, then that might not be negligent. But if a manufacturer doesn't do that or does a bad warning or it peels off easy or it's not in yellow, blah, 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 then that might be negligent. So that's generally the difference between negligent and strict products liability. Let's go to one of my captions. Visit us on the web at burgerlaw.com. We answer a lot of questions in our FAQ or frequently asked questions section of our website. We have a lot of videos on our YouTube channel that answers questions. We try to do this in a multiple of contexts. I got a lot of questions coming up. Let me see. I got a lot of them. Let me go to someone who I haven't gotten a question from.